Part B. Local Government. 38 Panchayati Raj. 39 Municipalities. 38 Panchayati Raj. The term Panchayati Raj in India signifies the system of rural local self-government. It has been established in all the states of India by the acts of the state legislatures to build democracy at the grassroots level. 1. It is entrusted with rural development. It was constitutionalized through the 73rd Constitutional Amendment Act of 1992. Evolution of Panchayati Raj. Sanghavi Mehta Committee. In January 1957, the Government of India appointed a committee to examine the working of the Community Development Programme, 1952, and the National Extension Service, 1953, and to suggest measures for their better working. The chairman of this committee was Sanghavi Mehta. The committee submitted its report in November 1957 and recommended the establishment of the scheme of democratic decentralization, which ultimately came to be known as Panchayati Raj. The specific recommendations made by it are: 1. Establishment of a three-tier Panchayati Raj system, Gram Panchayat at the village level, Panchayat Samiti at the block level and Zilla Parishad at the district level. These tiers should be organically linked through a device of indirect elections. 2. The village Panchayat should be constituted with directly elected representatives, whereas the Panchayat Samiti and Zilla Parishad should be constituted with indirectly elected members. 3. All planning and development activities should be entrusted to these bodies. 4. The Panchayat Samiti should be the executive body while the Zilla Parishad should be the advisory, coordinating and supervisory body. 5. The district collector should be the chairman of the Zilla Parishad. 6. There should be a genuine transfer of power and responsibility to these democratic bodies. 7. Adequate resources should be transferred to these bodies to enable them to discharge their functions and fulfill their responsibilities. 8. A system should be evolved to effect further devolution of authority in future. These recommendations of the committee were accepted by the National Development Council in January 1958. The council did not insist on a single rigid pattern and left it to the states to evolve their own patterns suitable to local conditions. But the basic principles and broad fundamentals should be identical throughout the country. Rajasthan was the first state to establish Panchayati Raj. The scheme was inaugurated by the Prime Minister on October 2, 1959, in Nagaur district. Rajasthan was followed by Andhra Pradesh, which also adopted the system in 1959. Thereafter, most of the states adopted the system. Though most of the states created Panchayati Raj institutions by mid-1960s, there were differences from one state to another with regard to the number of tiers, relative position of Samiti and Parishad, their tenure, composition, functions, finances, and so on. For example, Rajasthan adopted the three-tier system while Tamil Nadu adopted the two-tier system. West Bengal, on the other hand, adopted the four-tier system. Further, in the Rajasthan-Andhra Pradesh pattern, Panchayat Samiti was powerful as the block was the unit of planning and development, while in Maharashtra-Gujarat pattern, Zilla Parishad was powerful as the district was the unit of planning and development. Some states also established Nyaya Panchayats, that is, judicial panchayats to try petty civil and criminal cases. Study teams and committees. Since 1960, many study teams, committees, and working groups have been appointed to examine the various aspects of functioning of Panchayati Raj system. They are mentioned below in Table 38.1. Table 38.1 Study teams and committees on Panchayati Raj. SL No. Year. Name of the study team/committee. Chairman. 1. 1960. Committee on Rationalization of Panchayat Statistics. V.R. Rao. 2. 1961. Working Group on Panchayats and Cooperatives. S.D. Mishra. 3. 1961. Study Team on Panchayati Raj Administration. V. Iswaran. 4. 1962. Study Team on Nyaya Panchayats. G. R. Rajopal. 5. 1963. Study Team on the Position of Gram Sabha in Panchayati Raj Movement. R. Divakar. 6. 1963. Study Group on Budgeting and Accounting Procedure of Panchayati Raj Institutions. M. Ramakrishna Ya. 7. 1963. Study Team on Panchayati Raj Finances. K. Santhanam. 8. 1965. Committee on Panchayati Raj Elections. K. Santhanam. 9. 1965. Study Team on the Audit and Accounts of Panchayati Raj Bodies. R. K. Khanna. 10. 1966. Committee on Panchayati Raj Training Centers. G. Ramachandran. 11. 1969. Study Team on Involvement of Community Development Agency and Panchayati Raj Institutions in the Implementation of Basic Land Reform Measures. V. Ramanathan. 12. 1972. Working Group for Formulation of Fifth Five-Year Plan on Community Development and Panchayati Raj. N. Ramakrishna Ya. 13. 1976. Committee on Community Development and Panchayati Raj. SMT Dayat Ashok Mehta Committee. In December 1977, the Janata government appointed a committee on Panchayati Raj institutions under the chairmanship of Ashok Mehta. It submitted its report in August 1978 and made 132 recommendations to revive and strengthen the declining Panchayati Raj system in the country. Its main recommendations were: 1. The three-tier system of Panchayati Raj should be replaced by the two-tier system, that is, Zilla Parishad at the district level, and below it, the Mandal Panchayat consisting of a group of villages with a total population of 15,000 to 20,000. 2. A district should be the first point for decentralization under popular supervision below the state level. 3. Zilla Parishad should be the executive body and made responsible for planning at the district level. 4. There should be an official participation of political parties at all levels of Panchayat elections. 5. The Panchayati Raj institutions should have compulsory powers of taxation to mobilize their own financial resources. 6. There should be a regular social audit by a district-level agency and by a committee of legislators to check whether the funds allotted for the vulnerable social and economic groups are actually spent on them. 7. The state government should not supersede the Panchayati Raj institutions. In case of an imperative supersession, elections should be held within 6 months from the date of supersession. 8. The Naya Panchayats should be kept as separate bodies from that of development Panchayats. They should be presided over by a qualified judge. 9. The Chief Electoral Officer of a state in consultation with the Chief Election Commissioner should organize and conduct the Panchayati Raj elections. 10. Development functions should be transferred to the Zilla Parishad and all development staff should work under its control and supervision. 11. The voluntary agencies should play an important role in mobilizing the support of the people for Panchayati Raj. 12. A minister for Panchayati Raj should be appointed in the State Council of Ministers to look after the affairs of the Panchayati Raj institutions. 13. Seats for SCS and STS should be reserved on the basis of their population. 14. A constitutional recognition should be accorded to the Panchayati Raj institutions. This would give them the requisite status, sanctity and stature, and an assurance of continuous functioning. Due to the collapse of the Janata government before the completion of its term, no action could be taken on the recommendations of the Ashok Mehta Committee at the central level. However, the three states of Karnataka, West Bengal, and Andhra Pradesh took steps to revitalize the Panchayati Raj, keeping in view some of the recommendations of the Ashok Mehta Committee. G.V.K. Rao Committee. The committee to review the existing administrative arrangements for rural development and poverty alleviation programs under the chairmanship of G.V.K. Rao was appointed by the Planning Commission in 1985. The committee came to conclusion that the developmental process was gradually bureaucratized and divorced from the Panchayati Raj. This phenomena of bureaucratization of development administration as against the democratization weakened the Panchayati Raj institutions, resulting in what is aptly called as grass without roots. Hence, the committee made the following recommendations to strengthen and revitalize the Panchayati Raj system. I. The district-level body, that is, the Zilla Parishad, should be of pivotal importance in the scheme of democratic decentralization. It stated that the district is the proper unit for planning and development, and the Zilla Parishad should become the principal body for management of all development programs which can be handled at that level. 2. The Panchayati Raj institutions at the district and lower levels should be assigned an important role with respect to planning, implementation and monitoring of rural development programs. 3. Some of the planning functions at the state level should be transferred to the district-level planning units for effective decentralized district planning. 4. A post of District Development Commissioner should be created. He should act as the Chief Executive Officer of the Zilla Parishad and should be in charge of all the development departments at the district level. V. Elections to the Panchayati Raj institutions should be held regularly. It found that elections became overdue for one or more tiers in 11 states. Thus the committee, in its scheme of decentralist system of field administration, assigned a leading role to the Panchayati Raj in local planning and development. It is in this respect that the recommendation of the G.V.K. Rao Committee Report, 1986, differed from those of the Dentwala Committee Report on Block-Level Planning, 1978, and the Hanumantha Rao Committee Report on District Planning, 1984. Both the committees have suggested that the basic decentralist planning function should be done at the district level. The Hanumantha Rao Committee advocated separate district planning bodies under either the district collector or a minister. In both the models, the collector should play a significant role in the decentralist planning, though the committee stated that Panchayati Raj institutions would also be associated with this process of decentralist planning. The committee recommended that the collector should be the coordinator, at the district level, of all developmental and planning activities. Thus the Hanumantha Rao Committee differed in this respect from those of Balwant Mehta Committee, the Administrative Reforms Commission of India, the Ashok Mehta Committee, and finally the G.V.K. Rao Committee, which recommended reduction in the developmental role of the district collector and which assigned a major role to the Panchayati Raj in development administration. L.M. Sanghavi Committee. In 1986, Rajiv Gandhi government appointed a committee to prepare a concept paper on revitalization of Panchayati Raj institutions for democracy and development under the chairmanship of L.M. Sanghavi. It made the following recommendations. I. The Panchayati Raj institutions should be constitutionally recognized, protected and preserved. For this purpose, a new chapter should be added in the Constitution of India. This will make their identity and integrity reasonably and substantially inviolate. It also suggested constitutional provisions to ensure regular, free, and fair elections to the Panchayati Raj bodies. 2. Naya Panchayats should be established for a cluster of villages. 3. The villages should be reorganized to make Gram Panchayats more viable. It also emphasized the importance of the Gram Sabha and called it as the embodiment of direct democracy. 4. The village panchayats should have more financial resources. V. The judicial tribunals should be established in each state to adjudicate controversies about election to the Panchayati Raj institutions, their dissolution, and other matters related to their functioning. Thungan Committee. In 1988, a subcommittee of the Consultative Committee of Parliament was constituted under the chairmanship of P.K. Thungan to examine the political and administrative structure in the district for the purpose of district planning. This committee suggested for the strengthening of the Panchayati Raj system. It made the following recommendations. 1. The Panchayati Raj bodies should be constitutionally recognized. 2. A three-tier system of Panchayati Raj with panchayats at the village, block and district levels. 3. Zilla Parishad should be the pivot of the Panchayati Raj system. It should act as the planning and development agency in the district. 4. The Panchayati Raj bodies should have a fixed tenure of 5 years. 5. The maximum period of supersession of a body should be 6 months. 6. A planning and coordination committee should be set up at the state level under the chairmanship of the Minister for Planning. The presidents of Zilla Parishads should be its members. 7. A detailed list of subjects for Panchayati Raj should be prepared and incorporated in the Constitution. 8. Reservation of seats in all the 3 tiers should be on the basis of population. There should also be reservation for women. 9. A state finance commission should be set up in each state. It would lay down the criteria and guidelines for the devolution of finances to the Panchayati Raj institutions. 10. The district collector should be the chief executive officer of the Zilla Parishad. Godgil Committee. The Committee on Policy and Programs was constituted in 1988 by the Congress Party under the chairmanship of V. N. Godgil. This committee was asked to consider the question of how best Panchayati Raj institutions could be made effective. In this context, the committee made the following recommendations. 1. A constitutional status should be bestowed on the Panchayati Raj institutions. 2. A 3-tier system of Panchayati Raj with panchayats at the village, block and district levels. 3. The term of Panchayati Raj institutions should be fixed at 5 years. 4. The members of the panchayats at all the 3 levels should be directly elected. 5. Reservation for SCS, STS, and women. 6. The Panchayati Raj bodies should have the responsibility of preparation and implementation of plans for socio-economic development. For this purpose, a list of subjects should be specified in the Constitution. 7. The Panchayat Raj bodies should be empowered to levy, collect, and appropriate taxes and duties. 8. Establishment of a State Finance Commission for the allocation of finances to the panchayats. 9. Establishment of a State Election Commission for the conduction of elections to the panchayats. The above recommendations of the Godgil Committee became the basis for drafting an amendment bill aimed at conferring the constitutional status and protection to the Panchayati Raj institutions. Constitutional Ization. Rajiv Gandhi Government. The Rajiv Gandhi government introduced the 64th Constitutional Amendment Bill in the Lok Sabha in July 1989 to constitutionalize Panchayati Raj institutions and make them more powerful and broad-based. Although the Lok Sabha passed the bill in August 1989, it was not approved by the Rajya Sabha. The bill was vehemently opposed by the opposition on the ground that it sought to strengthen centralization in the federal system. VP Singh government. The National Front government, soon after assuming office in November 1989 under the Prime Ministership of VP Singh, announced that it would take steps to strengthen the Panchayati Raj institutions. In June 1990, a 2-day conference of the state chief ministers under the chairmanship of VP Singh was held to discuss the issues relating to the strengthening of the Panchayati Raj bodies. The conference approved the proposals for the introduction of a fresh constitutional amendment bill. Consequently, a constitutional amendment bill was introduced in the Lok Sabha in September 1990. However, the fall of the government resulted in the lapse of the bill. Narasimha Rao government. The Congress government under the Prime Ministership of P.V. Narasimha Rao once again considered the matter of the constitutionalization of Panchayati Raj bodies. It drastically modified the proposals in this regard to delete the controversial aspects and introduced a constitutional amendment bill in the Lok Sabha in September 1991. This bill finally emerged as the 73rd Constitutional Amendment Act, 1992 and came into force on April 24, 1932. 73rd Amendment Act of 1992. Significance of the Act. This Act has added a new Part 9 to the Constitution of India. This part is entitled as the Panchayats and consists of provisions from Articles 243 to 243A. In addition, the Act has also added a new 11th Schedule to the Constitution. This schedule contains 29 functional items of the Panchayats. It deals with Article 243G. The Act has given a practical shape to Article 40 of the Constitution, which says that, the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. This article forms a part of the directive principles of state policy. The Act gives a constitutional status to the Panchayati Raj institutions. It has brought them under the purview of the justiciable part of the Constitution. In other words, the state governments are under constitutional obligation to adopt the new Panchayati Raj system in accordance with the provisions of the Act. Consequently, neither the formation of panchayats nor the holding of elections at regular intervals depend on the will of the state government anymore. The provisions of the Act can be grouped into two categories, compulsory and voluntary. The compulsory, mandatory or obligatory, provisions of the Act have to be included in the state laws creating the new Panchayati Raj system. The voluntary provisions, on the other hand, may be included at the discretion of the states. Thus the voluntary provisions of the Act ensures the right of the states to take local factors like geographical, politico-administrative and others, into consideration while adopting the new Panchayati Raj system. The Act is a significant landmark in the evolution of grassroots democratic institutions in the country. It transfers the representative democracy into participatory democracy. It is a revolutionary concept to build democracy at the grassroots level in the country. Salient features. The salient features of the Act are: Gram Sabha. The Act provides for a Gram Sabha as the foundation of the Panchayati Raj system. It is a body consisting of persons registered in the electoral rolls of a village comprised within the area of Panchayat at the village level. Thus, it is a village assembly consisting of all the registered voters in the area of a Panchayat. It may exercise such powers and perform such functions at the village level as the legislature of a state determines. Three-tier system. The Act provides for a three-tier system of Panchayati Raj in every state, that is, Panchayats at the village, intermediate, and district levels 3. Thus, the Act brings about uniformity in the structure of Panchayati Raj throughout the country. However, a state having a population not exceeding 20 lakh may not constitute Panchayats at the intermediate level. Election of members and chairpersons. All the members of Panchayats at the village, intermediate, and district levels shall be elected directly by the people. Further, the chairperson of Panchayats at the intermediate and district levels shall be elected indirectly, by and from amongst the elected members thereof. However, the chairperson of a Panchayat at the village level shall be elected in such manner as the state legislature determines. The chairperson of a Panchayat and other members of a Panchayat elected directly or indirectly shall have the right to vote in the meetings of the Panchayats. Reservation of seats. The Act provides for the reservation of seats for scheduled castes and scheduled tribes in every Panchayat, i.e., at all the three levels, in proportion of their population to the total population in the Panchayat area. Further, the state legislature shall provide for the reservation of offices of chairperson in the Panchayat at the village or any other level for the SCS and STS. The Act provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging the SCS and STS. Further, not less than 1/3 of the total number of offices of chairpersons in the Panchayats at each level shall be reserved for women. The Act also authorizes the legislature of a state to make any provision for reservation of seats in any Panchayat or offices of chairperson in the Panchayat at any level in favor of backward classes. The reservation of seats as well as the reservation of offices of chairpersons in the Panchayats for the scheduled castes and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 70 years, that is, till 2020. It must be noted here that the above provision relating to the reservation of seats in Panchayats, both members and chairpersons, for the scheduled castes is not applicable to the state of Arunachal Pradesh. This is because the state is inhabited fully by indigenous tribal people and there are no scheduled castes. This provision was added later by the 83rd Constitutional Amendment Act of 2000. Duration of Panchayats. The Act provides for a 5-year term of office to the Panchayat at every level. However, it can be dissolved before the completion of its term. Further, Fresh elections to constitute a Panchayat shall be completed, a. before the expiry of its duration of 5 years, or, b. in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But, where the remainder of the period, for which the dissolved Panchayat would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new Panchayat for such period. Moreover, a Panchayat constituted upon the dissolution of a Panchayat before the expiration of its duration shall continue only for the remainder of the period for which the dissolved Panchayat would have continued had it not been so dissolved. In other words, a Panchayat reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. Disqualifications. A person shall be disqualified for being chosen as or for being a member of Panchayat if he is so disqualified, a. under any law for the time being in force for the purpose of elections to the legislature of the state concerned, or, b. under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Further, all questions of disqualifications shall be referred to such authority as the state legislature determines. State Election Commission. The superintendence, direction, and control of the preparation of electoral rolls and the conduct of all elections to the Panchayats shall be vested in the State Election Commission. It consists of a State Election Commissioner to be appointed by the Governor. His conditions of service and tenure of office shall also be determined by the Governor. He shall not be removed from the office except in the manner and on the grounds prescribed for the removal of a judge of the State High Court for. His conditions of service shall not be varied to his disadvantage after his appointment. The state legislature may make provision with respect to all matters relating to elections to the Panchayats. Powers and functions. The state legislature may endow the Panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon Panchayats at the appropriate level with respect to, a. the preparation of plans for economic development and social justice, b. the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 29 matters listed in the 11th Schedule. Finances. The state legislature may, a. authorize a Panchayat to levy, collect, and appropriate taxes, duties, tolls and fees, b. assign to a Panchayat taxes, duties, tolls and fees levied and collected by the state government, c. provide for making grants in aid to the Panchayats from the consolidated fund of the state, and d. provide for constitution of funds for crediting all monies of the Panchayats. Finance Commission. The governor of a state shall, after every 5 years, constitute a finance commission to review the financial position of the Panchayats. It shall make the following recommendations to the governor. 1. The principles that should govern. A. The distribution between the state and the Panchayats of the net proceeds of the taxes, duties, tolls and fees levied by the state and allocation of shares amongst the Panchayats at all levels. B. The determination of taxes, duties, tolls and fees that may be assigned to the Panchayats. C. The grants in aid to the Panchayats from the consolidated fund of the state. 2. The measures needed to improve the financial position of the Panchayats. 3. Any other matter referred to it by the governor in the interests of sound finance of the Panchayats. The state legislature may provide for the composition of the commission, the required qualifications of its members and the manner of their selection. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the Panchayats in the states, on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by the Panchayats and the auditing of such accounts. Application to Union territories. the provisions of this part are applicable to the Union territories. But, the President may direct that they would apply to a Union territory subject to such exceptions and modifications as he may specify. Exempted states and areas. The Act does not apply to the states of Nagaland, Meghalaya, and Mizoram and certain other areas. These areas include, a. the scheduled areas and the tribal areas in the states 5, b. the hill areas of Manipur for which district councils exist, and c. Darjeeling district of West Bengal for which Darjeeling Gorkha Hill Council exists. However, the Parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayats, Extension to the Scheduled Areas Act, 1996, popularly known as the PESA Act or the Extension Act. Continuance of existing laws and Panchayats. All the state laws relating to Panchayats shall continue to be in force until the expiry of 1 year from the commencement of this Act. In other words, the states have to adopt the new Panchayati Raj system based on this Act within the maximum period of 1 year from April 24, 1993, which was the date of the commencement of this Act. However, all the Panchayats existing immediately before the commencement of Act shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Consequently, majority of states passed the Panchayati Raj Acts in 1993 and 1994 to adopt the new system in accordance with the 73rd Constitutional Amendment Act of 1992. Bar to interference by courts in electoral matters. The Act bars the interference by courts in the electoral matters of Panchayats. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any Panchayat is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 11th Schedule. It contains the following 29 functional items placed within the purview of Panchayats. 1. Agriculture, including agricultural extension. 2. Land improvement, implementation of land reforms, land consolidation, and soil conservation. 3. Minor irrigation, water management, and watershed development. 4. Animal husbandry, dairying, and poultry. 5. Fisheries. 6. Social forestry and farm forestry. 7. Minor forest produce. 8. Small-scale industries, including food processing industries. 9. Khadi, village, and cottage industries. 10. Rural housing. 11. Drinking water. 12. Fuel and fodder. 13. Roads, culverts, bridges, ferries, waterways and other means of communication. 14. Rural electrification, including distribution of electricity. 15. Non-conventional energy sources. 16. Poverty alleviation program. 17. Education, including primary and secondary schools. 18. Technical training and vocational education. 19. Adult and non-formal education. 20. Libraries. 21. Cultural activities. 22. Markets and fairs. 23. Health and sanitation including hospitals, primary health centers and dispensaries. 24. Family welfare. 25. Women and child development. 26. Social welfare, including welfare of the handicapped and mentally retarded. 27. Welfare of the weaker sections, and in particular, of the scheduled castes and the scheduled tribes. 28. Public distribution system. 29. Maintenance of community assets. Compulsory and voluntary provisions. Now, we will identify separately the compulsory, obligatory or mandatory, and voluntary, discretionary or optional, provisions, features, of the 73rd Constitutional Amendment Act, 1992, or the Part 9 of the Constitution. A. Compulsory provisions. 1. Organization of Gram Sabha in a village or group of villages. 2. Establishment of Panchayats at the village, intermediate, and district levels. 3. Direct elections to all seats in Panchayats at the village, intermediate, and district levels. 4. Indirect elections to the post of chairperson of Panchayats at the intermediate and district levels. 5. Voting rights of the chairperson and other members of a Panchayat elected directly or indirectly. 6. 21 years to be the minimum age for contesting elections to Panchayats. 7. Reservation of seats, both members and chairpersons, for SCS and STS in Panchayats at all the 3 levels. 8. Reservation of 1/3 seats, both members and chairpersons, for women in Panchayats at all the 3 levels. 9. Fixing tenure of 5 years for Panchayats at all levels and holding fresh elections within 6 months in the event of supersession of any Panchayat. 10. Establishment of a state election commission for conducting elections to the Panchayats. 11. Constitution of a state finance commission after every 5 years to review the financial position of the Panchayats. B. Voluntary provisions. 1. Endowing the Gram Sabha with powers and functions at the village level. 2. Determining the manner of election of the chairperson of the village Panchayat. 3. Giving representation to the chairpersons of the village Panchayats in the intermediate Panchayats or in the case of a state not having intermediate Panchayats, in the district Panchayats. 4. Giving representation to the chairpersons of the intermediate Panchayats in the district Panchayats. 5. Giving representation to members of the Parliament, both the houses, and the state legislature, both the houses, in the Panchayats at different levels falling within their constituencies. 6. Providing reservation of seats, both members and chairpersons, for backward classes in Panchayats at any level. 7. Granting powers and authority to the Panchayats to enable them to function as institutions of self-government, in brief, making them autonomous bodies. 8. Devolution of powers and responsibilities upon Panchayats to prepare plans for economic development and social justice, and to perform some or all of the 29 functions listed in the 11th Schedule of the Constitution. 9. Granting financial powers to the Panchayats, that is, authorizing them to levy, collect, and appropriate taxes, duties, tolls and fees. 10. Assigning to a Panchayat the taxes, duties, tolls and fees levied and collected by the state government. 11. Making the grants in aid to the Panchayats from the consolidated fund of the state. 12. Providing for constitution of funds for crediting all monies of the Panchayats. PESA Act of 1996, Extension Act. The provisions of Part 9 of the Constitution relating to the Panchayats are not applicable to the 5th Schedule areas. However, the Parliament may extend these provisions to such areas, subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayats, Extension to the Scheduled Areas, Act, 1996, popularly known as the PESA Act or the Extension Act. At present, 2019, 10 states have 5th Schedule areas. These are, Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. All the 10 states have enacted requisite compliance legislations by amending the respective Panchayati Raj Acts. Objectives of the Act. The objectives of the PESA Act are as follows: 6. 1. To extend the provisions of Part 9 of the Constitution relating to the Panchayats to the scheduled areas with certain modifications. 2. To provide self-rule for the bulk of the tribal population. 3. To have village governance with participatory democracy and to make the Gram Sabha a nucleus of all activities. 4. To evolve a suitable administrative framework consistent with traditional practices. 5. To safeguard and to preserve the traditions and customs of tribal communities. 6. To empower Panchayats at the appropriate levels with specific powers conducive to tribal requirements. 7. To prevent Panchayats at the higher level from assuming the powers and authority of Panchayats at the lower level of the Gram Sabha. Features of the Act. The features, or the provisions, of the PESA Act are as follows. 1. A state legislation on the Panchayats in the scheduled areas shall be in consonance with the customary law, social and religious practices and traditional management practices of community resources. 2. A village shall ordinarily consist of a habitation or a group of habitations or a hamlet or a group of hamlets comprising a community and managing its affairs in accordance with traditions and customs. 3. Every village shall have a Gram Sabha consisting of persons whose names are included in the electoral rolls for the Panchayat at the village level. 4. Every Gram Sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, community resources, and the customary mode of dispute resolution. 5. Every Gram Sabha shall I. Approve of the plans, programs, and projects for social and economic development before they are taken up for implementation by the Panchayat at the village level, and 2. Be responsible for the identification of beneficiaries under the poverty alleviation and other programs. 6. Every Panchayat at the village level shall be required to obtain from the Gram Sabha a certification of utilization of funds for the above plans, programs, and projects. 7. The reservation of seats in the scheduled areas in every Panchayat shall be in proportion to the population of the communities for whom reservation is sought to be given under Part 9 of the Constitution. However, the reservation for the scheduled tribes shall not be less than 1/2 of the total number of seats. Further, all seats of chairpersons of Panchayats at all levels shall be reserved for the scheduled tribes. 8. The state government may nominate such scheduled tribes which have no representation in the Panchayat at the intermediate level or the Panchayat at the district level. But such nomination shall not exceed 1/10 of the total members to be elected in that Panchayat. 9. The Gram Sabha or the Panchayats at the appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development projects and before resettling or rehabilitating persons affected by such projects in the scheduled areas. However, the actual planning and implementation of the projects in the scheduled areas shall be coordinated at the state level. 10. Planning and management of minor water bodies in the scheduled areas shall be entrusted to Panchayats at the appropriate level. 11. The recommendations of the Gram Sabha or the Panchayats at the appropriate level shall be mandatory for grant of prospecting license or mining lease for minor minerals in the scheduled areas. 12. The prior recommendation of the Gram Sabha or the Panchayats at the appropriate level shall be mandatory for grant of concession for the exploitation of minor minerals by auction. 13. While endowing Panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of self-government, a state legislature shall ensure that the Panchayats at the appropriate level and the Gram Sabha are endowed specifically with I. The power to enforce prohibition or to regulate or restrict the sale and consumption of any intoxicant. 2. The ownership of minor forest produce. 3. The power to prevent alienation of land in the scheduled areas and to take appropriate action to restore any unlawfully alienated land of a scheduled tribe. 4. The power to manage village markets. V. The power to exercise control over money lending to the scheduled tribes. 6. The power to exercise control over institutions and functionaries in all social sectors. 7. The power to control local plans and resources for such plans including tribal sub-plans. 14. The state legislations shall contain safeguards to ensure that Panchayats at the higher level do not assume the powers and authority of any Panchayat at the lower level or of the Gram Sabha. 15. The state legislature shall endeavor to follow the pattern of the 6th schedule to the Constitution while designing the administrative arrangements in the Panchayats at district levels in the scheduled areas. 16. Any provision of any law, relating to Panchayats in the scheduled areas, which is inconsistent with the provisions of this Act shall cease to be in force at the expiry of 1 year from the date on which this Act receives the assent of the President. 7. However, all the Panchayats existing immediately before such date shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Finances of Panchayati Raj. The Second Administrative Reforms Commission of India, 2005 to 2009, has summarized the sources of revenue of the Panchayati Raj institutions, and their financial problems in the following way. 7a. 1. A major portion of Part 9 of the Constitution deals with structural empowerment of the PRI, but the real strength in terms of both autonomy and efficiency of these institutions is dependent on their financial position, including their capacity to generate own resources. In general, panchayats in our country receive funds in the following ways. I. Grants from the Union government based on the recommendations of the Central Finance Commission as per Article 280 of the Constitution. 2. Devolution from the state government based on the recommendations of the State Finance Commission as per Article 243 I. 3. Loan/grants from the state government. 4. Program-specific allocation under centrally sponsored schemes and additional central assistance. V. Internal resource generation, tax and non-tax. 2. Across the country, states have not given adequate attention to fiscal empowerment of the panchayats. The panchayats' own resources are meager. Kerala, Karnataka and Tamil Nadu are the states which are considered to be progressive in pre-empowerment, but even there, the panchayats are heavily dependent on government grants. One can draw the following broad conclusions. I. Internal resource generation at the panchayat level is weak. This is partly due to a thin tax domain and partly due to panchayats' own reluctance in collecting revenue. 2. Panchayats are heavily dependent on grants from union and state governments. 3. A major portion of the grants both from union as well as the state governments is scheme-specific. Panchayats have limited discretion and flexibility in incurring expenditure. 4. In view of their own tight fiscal position, state governments are not keen to devolve funds to panchayats. V. In most of the critical 11th Schedule matters like primary education, healthcare, water supply, sanitation and minor irrigation, even now, it is the state government which is directly responsible for implementation of these programs and hence expenditure. 6. Overall, a situation has been created where panchayats have responsibility but grossly inadequate resources. 3. Though, in absolute terms, the quantum of funds the union/state government transfers to a panchayat forms the major component of its receipt, the PRI's own resource generation is the soul behind its financial standing. It is not only a question of resources, it is the existence of a local taxation system which ensures people's involvement in the affairs of an elected body. It also makes the institution accountable to its citizens. 4. In terms of own resource collection, the gram panchayats are comparatively in a better position because they have a tax domain of their own, while the other two tiers are dependent only on tolls, fees and non-tax revenue for generating internal resources. 5. State Panchayati Raj Acts have given most of the taxation powers to village panchayats. The revenue domain of the intermediate and district panchayats, both tax as well as non-tax, has been kept much smaller and remains confined to secondary areas like ferry services, markets, water and conservancy services, registration of vehicles, cess on stamp duty and a few others. 6. A study of various state legislations indicates that a number of taxes, duties, tolls and fees come under the jurisdiction of the village panchayats. These inter alia include octroi, property/house tax, profession tax, land tax/cess, taxes/tolls on vehicles, entertainment tax/fees, license fees, tax on non-agriculture land, fee on registration of cattle, sanitation/drainage/conservancy tax, water rate/tax, lighting rate/tax, education cess, and tax on fairs and festivals. Reasons for ineffective performance. Even after conferring the constitutional status and protection through the 73rd Amendment Act, 1992, the performance of the Panchayati Raj institutions, PRI, has not been satisfactory and not up to the expected level. The various reasons for this suboptimal performance are as follows. 7b. 1. Lack of adequate devolution. Many states have not taken adequate steps to devolve 3Fs, i.e., functions, funds, and functionaries, to the PRI to enable them to discharge their constitutionally stipulated function. Further, it is imperative that the PRI have resources to match the responsibilities entrusted to them. While SFCs, state finance commissions, have submitted their recommendations, not many few states have implemented these or taken steps to ensure the fiscal viability of the PRI. 2. Excessive control by bureaucracy. In some states, the Gram Panchayats have been placed in a position of subordination. Hence, the Gram Panchayats or Panchs have to spend extraordinary amount of time visiting block offices for funds and or technical approval. These interactions with the block staff office distort the role of sarpanchs as elected representatives. 3. Tied nature of funds. This has two implications. The activities stated under a certain scheme are not always appropriate for all parts of the district. This results in unsuitable activities being promoted or an underspend of the funds. 4. Overwhelming dependency on government funding. A review of money received and own source funds shows the overwhelming dependence of panchayats on government funding. When panchayats do not raise resources and instead receive funds from outside, people are less likely to request a social audit. 5. Reluctance to use fiscal powers. An important power devolved to GP, Gram Panchayat, is the right to levy tax on property, business, markets, fairs, and also for services provided, like street lighting or public toilets, etc. Very few panchayats use their fiscal power to levy and collect taxes. The argument pushed by panchayat heads is that it is difficult to levy tax on your own constituency, especially when you live in the community. 6. Status of the Gram Sabha. Empowering the Gram Sabhas could have been a powerful weapon for transparency, accountability, and for involvement of the marginalized sections. However, a number of the state acts have not spelt the powers of Gram Sabhas, nor have any procedures been laid down for the functioning of these bodies or penalties for the officials. 7. Creation of parallel bodies. Often, parallel bodies, PBS, are created for supposedly speedy implementation and greater accountability. However, there is little evidence to show that such PBS have avoided the evils, including that of partisan politics, sharing of spoils, corruption, and elite capture. Missions, in particular, often bypassing mainstream programs, create disconnect, duality, and alienation between the existing and the new structures and functions. PBS usurp the legitimate space of PRI and demoralize the PRI by virtue of their superior resource endowments. 8. Poor infrastructure. A large number of Gram Panchayats in the country do not have even full-time secretary. Around 25% of the Gram Panchayats do not have basic office buildings. The database for planning, monitoring, etc., are lacking in most of the cases. A large number of elected representatives of PRI are semi-literate or literate and know little about their roles and responsibilities, programs, procedures, systems. Often for want of good, relevant, and periodic training, they are not able to perform their functions properly. Although all the district and intermediate panchayats are connected with computers, only around 20% Gram Panchayats reported to be having computing facility. In some states, village panchayats do not have any computing facility. Table 38.2 Articles related to panchayats at a glance. Article No. Subject Matter. 243. Definitions. 243a. Gram Sabha. 243b. Constitution of Panchayats. 243c. Composition of Panchayats. 243d. Reservation of Seats. 243e. Duration of Panchayats, and so on. 243f. Disqualifications for membership. 243g. Powers, authority, and responsibilities of Panchayats. 243h. Powers to impose taxes by, and funds of, the Panchayats. 243i. Constitution of Finance Commission to review financial position. 243j. Audit of accounts of Panchayats. 243k. Elections to the Panchayats. 243l. Application to Union Territories. 243m. Part not to apply to certain areas. 243n. Continuance of existing laws and Panchayats. 243a. Bar to interference by courts in electoral matters. Table 38.3 Name of Panchayati Raj institutions in the states, 2019, 8. SL No. State. Panchayati Raj institutions. 1. Andhra Pradesh. 1 Gram Panchayats 2. Mandal Parishads 3. Zilla Parishads. 2. Arunachal Pradesh. 1 Gram Panchayats 2. Anchal Samitis 3. Zilla Parishads. 3. Assam. 1 Gaon Panchayats 2. Ankalik Panchayats 3. Zilla Parishads. 4. Bihar. 1 Village Panchayats 2. Panchayat Samitis 3. Zilla Parishads. 5. Chhattisgarh. 1 Gram Panchayats 2. Janpad Panchayats 3. Zilla Panchayats. 6. Goa. 1 Village Panchayats 2. Zilla Panchayats. 7. Gujarat. 1 Village Panchayats 2. Taluka Panchayats 3. District Panchayats. 8. Haryana. 1 Gram Panchayats 2. Panchayat Samitis 3. Zilla Parishads. 9. Himachal Pradesh. 1 Gram Panchayats 2. Panchayat Samitis 3. Zilla Panchayats. 10. Jharkhand. 1 Gram Panchayats 2. Panchayat Samitis 3. Zilla Panchayats. 11. Karnataka. 1 Gram Panchayats 2. Taluka Panchayats 3. Zilla Panchayats. 12. Kerala. 1 Village Panchayats 2. Block Panchayats 3. District Panchayats. 13. Madhya Pradesh. 1 Village Panchayats 2. Block Panchayats 3. District Panchayats. 14. Maharashtra. 1 Village Panchayats 2. Panchayat Samitis 3. Zilla Parishads. 15. Manipur. 1 Gram Panchayats 2. Zilla Panchayats. 16. Odisha. 1 Gram Panchayats 2. Panchayat Samitis 3. Zilla Parishads. 17. Punjab. 1 Gram Panchayats 2. Panchayat Samitis 3. Zilla Parishads. 18. Rajasthan. 1 Gram Panchayats 2. Panchayat Samitis 3. Zilla Parishads. 19. Sikkim. 1 Gram Panchayats 2. Zilla Panchayats. 20. Tamil Nadu. 1 Village Panchayats 2. Panchayat Unions 3. District Panchayats. 21. Telangana. 1 Gram Panchayats 2. Mandal Parishads 3. Zilla Parishads. 22. Tripura. 1 Gram Panchayats 2. Panchayat Samitis 3. Zilla Panchayats. 23. Uttar Pradesh. 1 Gram Panchayats 2. Kshetra Panchayats 3. Zilla Panchayats. 24. Uttarakhand. 1 Gram Panchayats 2. Intermediate Panchayats 3. District Panchayats. 25. West Bengal. 1 Gram Panchayats 2. Panchayat Samitis 3. Zilla Parishads. Table 38.4 Milestones in the evolution of Panchayati Raj 9. I towards first generation Panchayats. 1948-49. Constituent Assembly debates on the role of Panchayati Raj in Indian polity. 1950. The Constitution of India comes into force on January 26. Directive principles of state policy mention village panchayats as units of self-government, Art 40. 1952. Community Development Program starts on 2 October. 1957. Sanghavi Mehta Committee, appointed in January, submits its report on November 24. 1958-60. Several state governments enact new Panchayat Acts bringing in three-tier Panchayat system. 1959. Jawaharlal Nehru inaugurates the first-generation Panchayat at Nagaur in Rajasthan on 2 October. Kerala District Council Bill is introduced in Kerala Assembly, lapses after Assembly is dissolved. 1964-77. Decline of first-generation Panchayati Raj institutions. 2. Growth and decline of second-generation Panchayats. 1978. Panchayat elections are held in West Bengal on party basis on 4 June, marking the beginning of second generation of Panchayati Raj. Ashok Mehta Committee on Working of Panchayats, appointed on December 12, 1977, submits its report on August 21. 1983. Karnataka government enacts new PR Act. 1984. Hanumantarao Committee on District Level Planning, appointed by Planning Commission in September 1982, submits its report in May. 1985. Karnataka PR Act receives President's assent in July, comes into force on 14 August. 1985. GVK Rao Committee on Administrative Aspects of Rural Development, appointed by Planning Commission on March 25, submits its report in December. 1986. Andhra Pradesh follows West Bengal and Karnataka Panchayati Raj model. 1987. Karnataka holds Panchayat elections in January. 1990-92. Panchayats are dissolved and brought under administrators in Karnataka. 3. Constitutional Ization of Panchayati Raj. 1986. Sanghavi Committee submits its report on November 27, recommends constitutional status for Panchayats. 1988. Consultative Committee of Parliament appoints a subcommittee under chairpersonship of P.K. Thungan to consider constitutional amendment. 1989. 64th Constitutional Amendment Bill is introduced in Parliament on May 15, is defeated in Rajya Sabha on October 15. 1990. 74th Constitutional Amendment Bill is introduced in Parliament on September 7, lapses on dissolution of Lok Sabha. 1991. 72 ND, Panchayats, and 73rd, Municipalities, amendment bills are introduced in Parliament, referred to the Parliament's Joint Select Committee in September. 1992. Lok Sabha passes both the bills on December 22, Rajya Sabha passes them on December 23. 1993. 73rd Amendment Act, 1992 comes into force on 24 April. 74th Amendment Act, 1992 comes into force on June 1. 1993-94. All state governments pass conformity acts between May 30, 1993 and April 23, 1994. 1994. Madhya Pradesh holds Panchayat elections under the 73 RD Amendment dispensation on May 30. 1996. Provisions of the Panchayats, Extension to the Scheduled Areas, Act, 1996, extending 73rd Amendment Act to Scheduled Areas, comes into force on 24 December. Kerala launches People's Plan campaign on August 16. 2001. Bihar holds Panchayat elections after 23 years, 11 to 30 April. 2001. 83 RD Constitutional Amendment Act, 2000 amends Art. 243 to dispense with reservations for scheduled castes in Arunachal Pradesh, paving way for Panchayat elections in the only state yet to hold them under the new dispensation. Table 38.5 Committees related to Panchayati Raj, after constitutionalization. SL No. Name of the committee. Chairman. Appointed in. Reported in. 1. Task Force on Devolution of Powers and Functions to Panchayati Raj Institutions. Lalit Mathur. 2001. 2001. 2. Expert Group on Planning at the Grassroots Level. V. Ramachandran. 2005. 2006. 3. Task Force for Preparation of a Manual for District Planning. SMT Rajwant Sandhu. 2008. 2008. 4. Committee on Restructuring of DRDA, District Rural Development Agency. V. Ramachandran. 2010. 2012. 5. Expert Committee on Leveraging Panchayats for Efficient Delivery of Public Goods and Services. Mani Shankar Ayar. 2012. 2013. Notes and references. 1. The subject of local government is mentioned in the state list under the 7th Schedule of the Constitution. 2. This bill was passed by the Lok Sabha on December 22, 1992, and by the Rajya Sabha on December 23, 1992. Later, it was approved by the 17 state assemblies and received the assent of the President on April 20, 1993. 3. The Act defines all these terms in the following manner. A. Panchayat means an institution, by whatever name called, of self-government for rural areas. B. Village means a village specified by the governor by public notification to be a village for this purpose, and includes a group of villages so specified. C. Intermediate level means a level between the village and district levels specified by the governor by public notification for this purpose. D. District means a district in a state. 4. A judge of a high court can be removed from his office by the President on the recommendation of the Parliament. This means that a state election commissioner cannot be removed by the governor, though appointed by him. 5. At present, 2019, 10 states of India have scheduled areas. These are, Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. Presently, 2019, there are a total of 10 tribal areas, autonomous districts, in the 4 states of Assam, 3, Meghalaya, 3, Tripura, 1, and Mizoram, 3. 6. S.K. Singh, Panchayats in Scheduled Areas, Kurukshetra, May 2001, p. 26. 7. This act received the assent of the President on December 24, 1996. 7. A Second Administrative Reforms Commission, Government of India, Report on Local Governance, 2007, pages 151 to 154. 7b Ministry of Panchayati Raj, Government of India, Roadmap for the Panchayati Raj, 2011 to 16, pages 11 to 12, 23, and 7 to 8. 8. Report of the 13th Finance Commission, 2010 to 2015, Volume 2, December 2009, pages 424 to 426. 9. Panchayati Raj Update, October, 2002, Institute of Social Sciences, New Delhi. 39 Municipalities. The term urban local government in India signifies the governance of an urban area by the people through their elected representatives. The jurisdiction of an urban local government is limited to a specific urban area which is demarcated for this purpose by the state government. 1. There are 8 types of urban local governments in India: municipal corporation, municipality, notified area committee, town area committee, cantonment board, township, port trust, and special purpose agency. The system of urban government was constitutionalized through the 74th Constitutional Amendment Act of 1992. At the central level, the subject of urban local government is dealt with by the following 3 ministries. I. Ministry of Housing and Urban Affairs. 2. Ministry of Defense in the case of cantonment boards. 3. Ministry of Home Affairs in the case of union territories. Evolution of urban bodies. Historical perspective. The institutions of urban local government originated and developed in modern India during the period of British rule. The major events in this context are as follows. In 1688, the first municipal corporation in India was set up at Madras. 2. In 1726, the municipal corporations were set up in Bombay and Calcutta. 3. Lord Mayo's resolution of 1870 on financial decentralization visualized the development of local self-government institutions. 4. Lord Ripon's resolution of 1882 has been hailed as the Magna Carta of local self-government. He is called as the father of local self-government in India. V. The Royal Commission on Decentralization was appointed in 1907 and it submitted its report in 1909. Its chairman was Hobhouse. 6. Under the diarchical scheme introduced in provinces by the Government of India Act of 1919, local self-government became a transferred subject under the charge of a responsible Indian minister. 7. In 1924, the Cantonments Act was passed by the central legislature. 8. Under the provincial autonomy scheme introduced by the Government of India Act of 1935, local self-government was declared a provincial subject. Committees and Commissions. The committees and commissions appointed by the central government to improve the functioning of urban local governments are mentioned below in Table 39.1. Constitutionalization. In August 1989, the Rajiv Gandhi government introduced the 65th Constitutional Amendment Bill, i.e., Nagarpalika Bill, in the Lok Sabha. The bill aimed at strengthening and revamping the municipal bodies by conferring a constitutional status on them. Although the bill was passed in the Lok Sabha, it was defeated in the Rajya Sabha in October 1989 and hence, lapsed. Table 39.1 Committees and Commissions on Urban Local Governments. SL No. Year. Name of the committee/commission. Chairman. 1. 1949-51. Local Finance Inquiry Committee. P.K. Vatal. 2. 1953-54. Taxation Inquiry Commission. John Mathai. 3. 1963-65. Committee on the Training of Municipal Employees. Nuruddin Ahmed. 4. 1963-66. Rural-Urban Relationship Committee. A.P. Jain. 5. 1963. Committee of Ministers on Augmentation of Financial Resources of Urban Local Bodies. Rafiq Zakaria. 6. 1965-68. Committee on Service Conditions of Municipal Employees. 7. 1974. Committee on Budgetary Reform in Municipal Administration. Grajapti Mukherjee. 8. 1982. Study Group on Constitution, Powers, and Laws of Urban Local Bodies and Municipal Corporations. K.N. Sahai. 9. 1985-88. National Commission on Urbanization. C.M. Korea. The National Front government under V.P. Singh introduced the revised Nagarpalika Bill in the Lok Sabha again in September 1990. However, the bill was not passed and finally lapsed due to the dissolution of the Lok Sabha. P.V. Narasimha Rao's government also introduced the Modified Municipalities Bill in the Lok Sabha in September 1991. It finally emerged as the 74th Constitutional Amendment Act of 1992 and came into force on June 1, 1932. 74th Amendment Act of 1992. This act has added a new Part 9A to the Constitution of India. This part is entitled as the Municipalities and consists of provisions from Articles 243p to 243zg. In addition, the Act has also added a new 12th Schedule to the Constitution. This schedule contains 18 functional items of municipalities. It deals with Article 243w. The Act gave constitutional status to the municipalities. It has brought them under the purview of justiciable part of the Constitution. In other words, state governments are under constitutional obligation to adopt the new system of municipalities in accordance with the provisions of the Act. The Act aims at revitalizing and strengthening the urban governments so that they function effectively as units of local government. Salient features. The salient features of the Act are: 3 types of municipalities. The Act provides for the constitution of the following 3 types of municipalities in every state. 1. A Nagar Panchayat, by whatever name called, for a transitional area. 3. 2. A municipal council for a smaller urban area. 3. A municipal corporation for a larger urban area. But, there is one exception. If there is an urban area where municipal services are being provided by an industrial establishment, then the governor may specify that area to be an industrial township. In such a case, a municipality may not be constituted. The governor has to specify a transitional area, a smaller urban area or a larger urban area, keeping in view the following factors. A. Population of the area. B. Density of the population therein. C. Revenue generated for local administration. D. Percentage of employment in non-agricultural activities. E. Economic importance. F. Such other factors as he may deem fit. Composition. All the members of a municipality shall be elected directly by the people of the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. The state legislature may provide the manner of election of the chairperson of a municipality. It may also provide for the representation of the following persons in a municipality. 1. Persons having special knowledge or experience in municipal administration without the right to vote in the meetings of municipality. 2. The members of the Lok Sabha and the State Legislative Assembly representing constituencies that comprise wholly or partly the municipal area. 3. The members of the Rajya Sabha and the State Legislative Council registered as electors within the municipal area. 4. The chairpersons of committees, other than wards committees. Wards committees. There shall be constituted a wards committee, consisting of 1 or more wards, within the territorial area of a municipality having population of 3 lakh or more. The state legislature may make provision with respect to the composition and the territorial area of a wards committee and the manner in which the seats in a wards committee shall be filled. Other committees. In addition to the wards committees, the state legislature is also allowed to make any provision for the constitution of other committees. The chairpersons of such committees may be made members of the municipality. Reservation of seats. The Act provides for the reservation of seats for the scheduled castes and the scheduled tribes in every municipality in proportion of their population to the total population in the municipal area. Further, it provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SCS and the STS. The state legislature may provide for the manner of reservation of offices of chairpersons in the municipalities for SCS, STS, and women. It may also make any provision for the reservation of seats in any municipality or offices of chairpersons in municipalities in favor of backward classes. The reservation of seats as well as the reservation of offices of chairpersons in the municipalities for the scheduled castes and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 70 years, that is, till 2020. Duration of municipalities. The Act provides for a 5-year term of office for every municipality. However, it can be dissolved before the completion of its term. Further, the fresh elections to constitute a municipality shall be completed, a. before the expiry of its duration of 5 years, or, b. in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But, where the remainder of the period, for which the dissolved municipality would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new municipality for such period. Moreover, A municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued had it not been so dissolved. In other words, a municipality reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. The Act also makes two more provisions with respect to dissolution. A municipality must be given a reasonable opportunity of being heard before its dissolution, and b. No amendment of any law for the time being in force shall cause dissolution of a municipality before the expiry of the 5 years term. Disqualifications. A person shall be disqualified for being chosen as or for being a member of a municipality if he is so disqualified, a. under any law for the time being in force for the purposes of elections to the legislature of the state concerned, or b. under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Further, all questions of disqualifications shall be referred to such authority as the state legislature determines. State Election Commission. The superintendence, direction, and control of the preparation of electoral rolls and the conduct of all elections to the municipalities shall be vested in the State Election Commission. The state legislature may make provision with respect to all matters relating to elections to the municipalities. Powers and functions. The state legislature may endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon municipalities at the appropriate level with respect to a. the preparation of plans for economic development and social justice, b. the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 18 matters listed in the 12th Schedule. Finances. The state legislature may, a. authorize a municipality to levy, collect, and appropriate taxes, duties, tolls and fees, b. assign to a municipality taxes, duties, tolls and fees levied and collected by state government, c. provide for making grants in aid to the municipalities from the consolidated fund of the state, and d. provide for constitution of funds for crediting all monies of the municipalities. Finance Commission. The Finance Commission, which is constituted for the Panchayats, shall also, for every 5 years, review the financial position of municipalities and make recommendation to the governor as to 1. The principles that should govern a. the distribution between the state and the municipalities of the net proceeds of the taxes, duties, tolls and fees levied by the state and allocation of shares amongst the municipalities at all levels. b. the determination of the taxes, duties, tolls and fees that may be assigned to the municipalities. c. the grants in aid to the municipalities from the consolidated fund of the state. 2. the measures needed to improve the financial position of the municipalities. 3. any other matter referred to it by the governor in the interests of sound finance of municipalities. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the municipalities in the state, on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by municipalities and the auditing of such accounts. Application to Union Territories. The provisions of this part are applicable to the Union Territories. But, the President may direct that they would apply to a Union Territory subject to such exceptions and modifications as he may specify. Exempted areas. The Act does not apply to the scheduled areas and tribal areas in the states for. It shall also not affect the functions and powers of the Darjeeling Gorkha Hill Council of the West Bengal. However, the Parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modifications as it may specify. District Planning Committee. Every state shall constitute at the district level, a district planning committee to consolidate the plans prepared by panchayats and municipalities in the district, and to prepare a draft development plan for the district as a whole. The state legislature may make provisions with respect to the following. 1. The composition of such committees. 2. The manner of election of members of such committees. 3. The functions of such committees in relation to district planning, and 4. The manner of the election of the chairpersons of such committees. The Act lays down that 4/5 of the members of a district planning committee should be elected by the elected members of the district panchayat and municipalities in the district from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the rural and urban populations in the district. The chairperson of such committee shall forward the development plan to the state government. In preparing the draft development plan, a district planning committee shall a. Have regard to I. Matters of common interest between the panchayats and the municipalities, including spatial planning, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. 2. The extent and type of available resources, whether financial or otherwise, and b. Consult such institutions and organizations as the governor may specify. Metropolitan Planning Committee. Every metropolitan area shall have a Metropolitan Planning Committee to prepare a draft development plan. 5. The state legislature may make provisions with respect to the following. 1. The composition of such committees. 2. The manner of election of members of such committees. 3. The representation in such committees of the central government, state government, and other organizations. 4. The functions of such committees in relation to planning and coordination for the metropolitan area, and 5. The manner of election of chairpersons of such committees. The Act lays down that 2/3 of the members of a Metropolitan Planning Committee should be elected by the elected members of the municipalities and chairpersons of the panchayats in the metropolitan area from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the population of the municipalities and the panchayats in that metropolitan area. The chairpersons of such committees shall forward the development plan to the state government. In preparing the draft development plan, a Metropolitan Planning Committee shall a. Have regard to I. The plans prepared by the municipalities and the panchayats in the metropolitan area. 2. Matters of common interest between the municipalities and the panchayats, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. 3. The overall objectives and priorities set by the Government of India and the Government of the State. 4. The extent and nature of investments likely to be made in the metropolitan area by agencies of the Government of India and of the Government of the State and other available resources, whether financial or otherwise, and b. Consult such institutions and organizations as the governor may specify. Continuance of existing laws and municipalities. All the state laws relating to municipalities shall continue to be in force until the expiry of 1 year from the commencement of this Act. In other words, the states have to adopt the new system of municipalities based on this Act within the maximum period of 1 year from June 1, 1993, which is the date of commencement of this Act. However, all municipalities existing immediately before the commencement of this Act shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Bar to interference by courts in electoral matters. The Act bars the interference by courts in the electoral matters of municipalities. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any municipality is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 12th Schedule. It contains the following 18 functional items placed within the purview of municipalities. 1. Urban planning including town planning. 2. Regulation of land use and construction of buildings. 3. Planning for economic and social development. 4. Roads and bridges. 5. Water supply for domestic, industrial, and commercial purposes. 6. Public health, sanitation, conservancy, and solid waste management. 7. Fire services. 8. Urban forestry, protection of the environment and promotion of ecological aspects. 9. Safeguarding the interests of weaker sections of society, including the handicapped and mentally retarded. 10. Slum improvement and upgradation. 11. Urban poverty alleviation. 12. Provision of urban amenities and facilities such as parks, gardens, playgrounds. 13. Promotion of cultural, educational, and aesthetic aspects. 14. Burials and burial grounds, cremations and cremation grounds and electric crematoriums. 15. Cattle ponds, prevention of cruelty to animals. 16. Vital statistics including registration of births and deaths. 17. Public amenities including street lighting, parking lots, bus stops and public conveniences, and 18. Regulation of slaughterhouses and tanneries. Types of urban governments. The following 8 types of urban local bodies are created in India for the administration of urban areas. Municipal corporation. Municipality. Notified Area Committee. Town Area Committee. Cantonment Board. Township. Port Trust. Special Purpose Agency. 1. Municipal Corporation. Municipal Corporation